Council, so that you're aware, I don't expect that the judges will expect you to wear masks. They will wear them as they're coming in and then we'll take them off. Okay, so I expect that they'll invite you to do the same if you haven't already taken yours off. Thank you. Thank you.
All right. What are you doing back over here, see? Short and sweet, isn't it? At least you know the way around, don't you? Yeah.
So they'll resolve here today?
Yes.
So what I just said is that I'll just knock on the door as they come. And I've also had you know the smaller courts?
Yeah.
I think they're going to be quite close, so it's between us. They're going to be just in the news that London's going into.
Yes, I started. They're going to India.
The high very bad.
Yeah.
Safe, unsafe, or deadly, they should call it.
So it's just the small courts at the moment that are getting between the courts.
Well, I'm not sure. You know, obviously there's the 6 foot between these.
Yeah.
So that's fine. And we can put all the paper on the screen as well.
Everyone brought water.
Yeah, thanks. Yes, yes. Yeah.
They're ready. The court's ready, I presume.
We are ready. Yeah.
Okay.
Good plan.
Nearly ready.
It's been a while.
Silence, call to rise. Appeal in the matter of Wright and Granath.
Yes.
may it please your lordships, in this matter I appear with Miss Walker-Parr, as well as Mr. Callis, who is appearing remotely, albeit I understand with a 30-second delay, for the appellant Dr. Wright. Mr. Tomlinson, Queen's Counsel, and Mr. Hutchin appear for the respondent, Mr. Granath. My lords, the facts of this case are straightforward. In brief, they are that Mr. Granath, anonymously from Norway, posted material on his Twitter feed. Dr. Wright saw that material. He did not know who was posting it, so he sought to contact Mr. Granath through his solicitors on the 29th of March of 2019 through the Twitter account. And on that occasion, he sent a letter of claim. He asked Mr. Granath to identify himself. He asked Mr. Granath to apologise publicly, and he asked for Mr. Granath to join in the statement in open court and to undertake not to repeat the libel. Dr. Wright also wrote shortly after that to Twitter through his solicitors, asking for them to provide the identity of Mr. Granath, or the identity of the person posting the defamatory matter. On the 15th of May last year, Dr. Wright's solicitors wrote to Mr. Granath, again through the Twitter account, stating they believed they had identified him as the poster of the tweets, as Hodlanaut. And they asked him to confirm that he was indeed Hodlanaut for the purpose of legal proceedings. Mr. Granath responded by confirming his identity as Hodlanaut, but did not reply substantively to the letter of claim. That was on the 15th of May. It was then on the 4th of June, so shortly afterwards, that Mr. Granath issued his claim in Norway for negative declaratory relief. So by that time, Mr. Granath had not responded substantively to the letter of claim. The Norwegian court is therefore the court first seized. When Dr. Wright subsequently did sue in England on the 6th of August, Mr. Granath responded by immediately making this application under Article 27 for a stay of the proceedings and subsequently for an order that the court declined jurisdiction. Mr. Justice Jay concluded that the test under Article 27 was met, and he declined jurisdiction because by the time the matter came on before him in December of last year, the Norwegian court had ruled that it did indeed have jurisdiction. My lords, there are two grounds of appeal that we mount today. The first ground, and the main ground, the judge was wrong to find that the two sets of proceedings in England and Norway concerned the same cause of action for the purposes of Article 27 of the Lugano Convention. If I may, I'd like to say a few words about Article 27.
Just before you do, Mr. Moylan, can I just ask you what your submission is on how this court, being an appellate court, must approach that first ground? You said the judge was wrong in applying Article 27.
Yes.
What is our function? Are we simply substituting our own view for that of the first instance court? How do we go about our task?
Yeah, in my submission, yes. We say that the judge was wrong in the way he approached it. It was a binary question. It wasn't a question of discretion, and that this court should substitute its own view. The leading authority on Article 27 in this jurisdiction is the Alexandros T case.
Can I just, sorry, Mr. Wolanski, there's the unagreed supplementary appeal bundle. Are you coming to that in due course?
I'm not, just so your lordship knows, I'm not going to say that this court needs to have a look at what's in that.
Right, thank you.
You can put it to one side.
Thank you.
The Alexandros T is at tab 9 of the bundle of authorities. and it is the leading case in this jurisdiction on the application of Article 27. Can I ask you please to look first of all at paragraph 23 of the judgment of Lord Clark, which is found at starts at page 602. Where the learned judge first of all explains the context of Article 27, and over the page at 603 refers to recital 15 to the applicable instrument, which is the Brussels Convention, in that case, equivalent to all intents and purposes the Lugano Convention, which says this, and this is at B, recital 15 provides in the interest of the harmonious administration of justice, it is necessary to minimise the possibility of concurrent proceedings and to ensure that irreconcilable judgments will not be two member states. So that is the guiding principle behind the Liz Pendens provisions that follow. Then in paragraph 24 is set out the terms of Article 27, 28, 29 and 30. It's only 27 which is in play on the current application, and that reads as follows, where proceedings involving the same cause of action and between the same parties are brought in the courts of different member states, any court other than the court first seized shall, of its own motion, stay its proceedings until such time as the jurisdiction of the court first seized is established. 2, where the jurisdiction of the court first seized is established, any court other than the court first seized shall decline jurisdiction in favour of that court. As I say, by the time the matter had got before Mr. Justice J, the Norwegian court had held it did have jurisdiction. There was a challenge to that jurisdiction by Dr. Wright in Norway, and that challenge failed. So the court had found that it had jurisdiction, therefore the judge declined jurisdiction.
Was the decision from the Norwegian Court of Appeal being itself appealed?
It was appealed. It was appealed to the Norwegian Appeal Court. That appeal was unsuccessful.
Yes.
That was then appealed to the Supreme Court in Norway, and that also has been dismissed.
Yes.
So the Norwegian court has jurisdiction.
Yes. In terms of Article 28, which, as I say, are not in play in the current application, but nevertheless are relevant for purposes of comparison, are as follows, where related actions are pending in the courts of different member states, any court other than the court first seized may stay its proceedings. So that gives rise to a discretion on the part of the court, other than the court first seized, where there are related actions. And then there's another provision related to consolidation, and then 3 says, for the purposes of this article, actions are deemed to be related, where they are so closely connected that it is expedient to hear and determine them together to avoid the risk of irreconcilable judgments resulting from separate proceedings. So the terminology of a risk of irreconcilable judgments appears in Article 28, but not in Article 27. And as I say, Article 28, the structure of it is quite different because rather than resulting in a mandatory outcome, it gives the court a discretion to take into account a number of different factors that may arise. But Mr. Granath did not make an application in the current proceedings under Article 28, it's solely Article 27. Turning over the page, Lord Clark summarises the relevant principles on Article 27, starting at paragraph 28. At the bottom of the page at J, he says the phrase same cause of action in Article 27 has an independent and autonomous meaning as a matter of European law. It's therefore not to be interpreted according to the criteria of national law. So just because something is not a cause of action as an English law would understand that term is not the end of the matter. 2, in order for proceedings to involve the same cause of action, they must have le même objet et la même cause. This expression derives from the French version of the text, not reflected expressly in the English or German texts,
but it applies generally. 3. Identity of cause means that the proceedings in each jurisdiction must have the same facts and rules of law relied on as the basis for the action. Those words are important. The basis for the action. See the Tatry. And then a passage from the judgment of Mr. Justice Cook in the Primacom case is cited as follows. The expression legal rule or rule of law appears to mean that the juridical basis upon which arguments as to the facts will take place, so that investigating cause, the court looks to the basic facts, whether in dispute or not, and the basic claimed rights and obligations of the parties, to see if there is coincidence between them in the actions in different countries, making due allowance for the specific form that proceedings may take in one national court with different classifications of rights and obligations from those in a different national court. Identity of object, number 4, means the proceedings in each jurisdiction must have the same end in view. 5, and this is important on this appeal, the assessment of identity of cause and identity of object is to be made by reference only to the claims in each action and not to the defences to those claims. See the Gantler case, where the CJEU said, in order to determine whether two claims brought between the same parties before the courts of different contracting states have the same subject matter, account should be taken only of the claims of the respective applicants, to the exclusion of the defence submissions raised by a defendant. As I say, as we'll see, that has some significance on the current appeal. 6, it follows that Article 27 is not engaged merely by virtue of the fact that common issues might arise in both sets of proceedings. I would accept the submission on behalf of CMI that this is an important point of distinction between Articles 27 and 28. Under Article 28, it is actions rather than claims that are compared in order to determine whether they are related. And then 7, there's a citation from the judgment of Mr. Justice Ricks in the Glencore case. It would appear from these first 5 cases, of which the first 2 were in the European Court, and 3 in domestic courts of England, that broadly speaking, the triple requirements of the same party, same cause, and same object entails that it is only in relatively straightforward situations that Article 21 bites. And I should say Article 21 is the equivalent provision under the Brussels regulation to Article 27. And it may be said, is intended to bite. After all, Article 22 is available with its more flexible discretionary power, that of course being the equivalent to Article 28, in the case of related proceedings, which need not involve the triple requirement of Article 21. There is no need, therefore, as it seems to me, to strain to fit into Article 21. And just pausing there, a central submission that we make on this appeal is that is the trap into which Mr. Justice Jay felt he strained to fit this case into Article 27. Going back then to the judgment, the European Court, when speaking in the Gubish case, at 4874, the purpose and the interests of the proper administration of justice within the European community of preventing parallel proceedings in different jurisdictions and of avoiding, insofar as it is possible and from the outset, the possibility of irreconcilable decisions when addressing Articles 21 and 22 together. And then some examples are given of the application of Article 21, as it is in that case, which I needn't go through. But moving down to paragraph 29, further down the page, one sees that the learned judge addresses the position in that case, asking how do these principles provide an answer to the question whether 2006 proceedings involve the same causes of action as the Greek proceedings. He says it's necessary to consider the claims advanced by CMI and OMI separately, and in the case of each cause of action relied on, to consider whether the same cause of action is being relied on in the Greek proceedings. In doing so, the defences advanced in each action must be disregarded. And one can see that what the learned judge is saying there is that you disregard the defences actually advanced. And a
point that is made against me on this appeal is that does not preclude the court from looking at defences that might be advanced. But in my submission, that must be wrong, that the greater includes the lesser. The court is precluded not just from looking at defences which are actually advanced, but from speculating as to what defences might be advanced, which is what, in my submission, the judge did in the current case. And then, 30, the essential question is whether the claims in England and Greece are mirror images of one another, and thus legally irreconcilable, as in the Gubish case and the Taptree, or whether they are not incompatible, as in the Gantner case, in which case it does not. So that is the essential question which the court has to ask. Moving on then to the facts of the current case, the court is required to look at the claims advanced in each jurisdiction, and that is what I'm going to invite the court to do now. Can I ask you please to go to the core appeal bundle? Particulars of claim in the English law, which are tab 11. They start by introducing the claimant, computer scientist and businessman in England and Wales, identify the defendant. Paragraph 3 sets out the one tweet which is complained of as defamatory in those proceedings, with a date and the location where it was published. The words being the forensic to CSW's first attempt to fraudulently prove he is Satoshi, enabled by Gavin Anderson. Never forget, Craig Wright is a fraud. And then in paragraph 4, the meaning of the words which the claimant contends the words bear is set out. Well, first of all, sorry, set out the particulars of reference, because it's not completely obvious that the words refer to this claimant. So paragraph 4 sets out why it is that readers would have understood the words to refer to the claimant. And as part of that plea, reference is made to other tweets which were published by the defendant around the same time, where the claimant is specifically named. And as we'll see when we come to the Norwegian case, those other tweets are relied on in the Norwegian case, but as part of the basis for the claim. So here they're only relied on as part of the particulars of reference, but they're not sued on as being defamatory. Paragraph 5 sets out the innuendo meaning which the claimant says the words bear, and that meaning is that the claimant had fraudulently claimed to be Satoshi Nakamoto, that is to say the person or one of the group of people who developed the cryptocurrency Bitcoin. And then, as claimants are required to do, there are particulars of extraneous facts set out in the following subparagraph. So those are the facts which readers are said to have known, and which, when they read the tweet complained of, would have led them to understand the words to bear that meaning. And then in paragraph 6 is an averment of serious harm caused to the claimant's reputation. There's reference made to the number of followers, of the feed and seriousness of the allegations. It's also pleaded, paragraph 7, that the publication caused injury to the claimant's feelings. And then matters are set out in support of the claim for damages at paragraph 8. So other tweets which were published by the defendant are set out there. And they are said to have aggravated the damage to the claimant's reputation. But importantly, they are not part of the cause of action. There is only the one tweet which is part of the cause of And then the claim is for damages in the prayer for an injunction for an order under Section 12 of the Defamation Act requiring the defendant to publish a summary of the judgment in the proceedings. And that's it. So that is the scope of the claim. Now, as the judge correctly pointed out in this case, it was not incumbent on Dr. Wright to say anything else in his claim. So there is no averment of falsity. Had this been a claim for malicious falsehood, then of course there would have had to be, and particulars of falsity would have had to be pleaded. But it is not, it is a claim for libel, so all that Dr. Wright was required to do in the particulars of the claim is set out those particulars which he set out. So it is not said that the words are false, and neither is it said that they were published on an occasion, that they were not published on an occasion of public interest. Again, we'll see in Norwegian proceedings that is a feature of that claim. With that in mind, can I ask you please to look at the opening writ in the Norwegian case, which is at tab
Sorry to
12A.
interrupt you, just before you do this. So this is a global damages
It is.
claim. It's not a mosaic claim.
No, it's a global damages claim. That's right. The opening writ in the Norwegian case is at paragraph 12A.
Sorry, forgive me. I think my friend is mistaken about his own claim. If he looks at paragraph 6 of the particulars of the claim.
No, it's right that paragraph 6 identifies the serious harm caused to the claimant's reputation in this jurisdiction, because in satisfying the Section 1 test, you have to show serious harm in this jurisdiction. But the injunction that is sought is not limited to this jurisdiction. So the injunction which is sought in paragraph 9b is a general injunction. So, as I say, the reason why paragraph 6 is there is because of the statutory requirement to show serious harm in this reputation, in this jurisdiction. It is a claim for global damages.
And an injunction can only be claimed in a jurisdiction where there is global damages.
Well, either where there is, yeah, exactly, yes, that's the Bowling Supply case. So it is necessary for Dr. Wright to claim globally in order to seek an injunction. In respect of online publication, your Lordship's right that, of course, that principle is confined to online publication, but this is online publication. So it is a claim for global relief. Turning then to the Norwegian opening writ. Which is at paragraph 12A. There's an introductory section, page 99. Mr. Magnus Granath hereby files suit against Mr. Craig Wright, claiming a declaratory judgment that Granath is not liable to pay damages to Wright. Wright has claimed that Granath has made libelous remarks about Wright on Twitter, and that Wright has a claim for damages against Granath. Granath disputes the claims and asks for an exculpatory judgment in his favour. Wright's resident in England, the alleged libelous remarks made on Twitter by Granath, who's resident in Norway. The tweets, so it's plural, so it's apparent that this is a claim in relation to more than one tweet, were deleted on 9th of April 2019. The alleged libelous actions took place in Norway, and Norwegian courts have jurisdiction on the Convention, Article 5.3. There's reference to the Conciliation Board, procedural mechanism in Norway. Facts of the case. The pseudonym Satoshi Nakamoto is used by the personal group of persons who were behind the famous cryptocurrency Bitcoin, launched in 2008. Who is behind the pseudonym is unknown, but Craig Wright claimed at some point in 2015 that he was behind the pseudonym. The evidence on which Wright supported his claim has been contested, and from many quarters it has been maintained that the claim is incorrect. And I emphasise that word because what is lacking from this document is any allegation that the claim was dishonest. We say that's an important point of distinction between this claim and the English claim, where your Lordships will have seen that the allegation complained of is one of dishonesty. But here, all Mr. Granath contends is that the claim is incorrect. Then he refers to other articles that where people have discussed the matter. He says one of the people who alleged the claim was incorrect is the plaintiff in this case. He was behind the Twitter account Popplwewell, which has about 8,000 followers, 7% in England. The tweets are about the technology market in general. A few of the messages concerned Craig Wright and his claim to be Satoshi. Wright has threatened to file a suit or file suits against several of the people who claimed he was not Satoshi in order that they will withdraw what are, in his opinion, incorrect allegations. So there again, it is not alleged that the allegations were made, that the assertion of being Satoshi was made dishonestly. Wright did the same against Granath. He reacted in particular to the tweets from March 2019. And then there is exhibited to the claim a summary of the tweets from March 2019. Now, those are not in this tab, but can I invite you, please, so that you can see what the scope of that claim is, to look at File 2, that's the Supplementary Appeal Bundle, tab 7. Page 151. This is the document which Mr. Granath is referring to in his opening writ. Looking at that, you can see there are a variety of tweets which Mr. Granath is referring to. The first reads, "A lot of damage is still being done. I have nothing but contempt for trash like Roger, Fake Toshi, Pedo Calvin, all their enabling scum." Next is one, Hodler tweets, "Craig Wright is a very sad and pathetic scammer, clearly mentally ill. Everything about him induces deep cringe. I suffer from obviousness fatigue after still having to read posts arguing why he isn't Satoshi." Next, Hodler tweets, "As a tribute to Craig Wright being a fraud, I'm going to make next week Craig Wright is a fraud week and tag all my tweets with hashtag Craig Wright is a fraud. Feel free to join the celebration. The space is so fascinating. It has people of the absolute highest calibre intellectually and ethically. It also has individuals representing the scummiest sides of humanity, supported by people with vegetable brain power." And then here's the tweet complained of in this case. "The forensics to CSW's first attempt to fraudulently prove he is Satoshi, enabled by Gavin Andrewson. Never forget Craig Wright is a fraud." Next, "Craig Wright is a fraud, the chain goes strong." Next, "The fact that Twitter agrees Craig Wright is a fraud must surely be causing a serious meltdown as we speak. Long on popcorn for the next couple of days." Next, "Happy Craig Wright is a fraud week, everyone." Craig Wright is a fraud week gets off to a flying start with the fraud himself disappearing from Twitter on day one. Double taco rations tonight. The point we make about this is that not only is the scope of the claim in Norway for negative declaratory relief wider because it relates to a variety of tweets, but those tweets make a variety of allegations beyond simply the allegation that Craig Wright has made a fraudulent claim to be Satoshi. They are what an English libel lawyer would recognise as general allegations of fraud, which might potentially be defensible by reference to other matters beyond anything to do with Dr. Wright's claim to be Satoshi. Plus, of course, there are various allegations about him being a scammer and mentally ill and so on. So in England, if this were the subject, if these were sued on, it would potentially be open to a defendant to defend the claim by reference to a variety of different matters, not just the allegation that Dr. Wright has fraudulently claimed to be Satoshi. But of course that is not what Dr. Wright has done in his English case. Going back then to the opening writ, Wright, who at the time did not know the identity behind the account, sent a letter to Hodler where he demanded the owner withdraw his allegations. There's some correspondence then set out.
And then this, the basis of claim. We argue that Norwegian law shall be relied on for damages following alleged libelous statements which were made in or from Norway, regardless of whether accessible outside Norway, the EU, or other places. Norwegian law must therefore apply to the claim from Wright. Now, I anticipate your Lordships may ask the same question asked by my Lord Justice Popplwewell. This is a claim for global damages. On the face of it, it's not obvious, but that's what the Norwegian court has found. In order that Wright shall have a claim for damages resulting from Granath's allegations on Twitter, the allegations must be made negligently and they must be libellous and unlawful. So there's an assertion of negligence and there's an assertion that the words were libellous and unlawful. What follows is important in our submission. Granath believes he can substantiate that Wright is not Satoshi and that Granath's allegations are therefore correct. Therefore, they're not libellous. And what Mr. Granath there is asserting stops short of alleging fraud. He is not saying that Dr. Wright has been fraudulent, or that he's going to invite the Norwegian court to find that Dr. Wright has been fraudulent. And this is important because were the Norwegian court to find no more than that Dr. Wright is not Satoshi, but stop short of finding that he made the claim fraudulently, and an example might be if Satoshi it finds was maybe more than one person. There are a number of people who were responsible for the white paper, which sets out the core concepts of Bitcoin, and Dr. Wright is not the main author, he's not the main person, so he can't claim to be Satoshi, but he honestly believed that he was Satoshi because of the extent of his contribution. That's a possible outcome. In those circumstances, the Norwegian court will have found exactly what Mr. Granath is asking them to find, namely that he's not Satoshi, but would not have found Dr. Wright to have made the claim fraudulently or dishonestly. That's a possible outcome, and as I say, that's exactly what Mr. Granath is asking the Norwegian court to do, and no more. Therefore, carrying on with the opening writ, they're not libellous. Neither has Granath acted negligently in relation to the statements. Of course, negligence is not a feature of the English tort. In any case, Granath had honourable reasons to put forward the allegations. Freedom of expression is a key human right under both the Constitution of the Kingdom of Norway, Article 100, and the European Convention of Human Rights, Article 10. Granath's statements are within the wide framework of freedom of expression that these rules established. These means that statements are not unlawful, regardless of whether they're accessible in Norway. So Mr. Granath is saying the allegations are true and allege that Wright is not Satoshi, and in addition, essentially it's a form of public interest defence that's being asserted, saying that these fall within the ambit of the Article 10 defence. In the alternative, we'll argue that even if the statements were libellous, Craig Wright has not suffered any loss. There is therefore no basis on which to award him reputation for non-economic loss. His reputation was long damaged even before he put forth the allegations on Twitter. So that is an assertion as to damages. It's not what would qualify as a substantive defence in this case, but it is an answer to the claim on damages. Accordingly, we ask the court to find in favour of Granath regarding the claims by Wright. We also ask for a declaratory judgment that Granath's statements on Twitter about Wright are lawful. And then the statement claim is the court finds in favour of Magnus Granath in regard to the claim for damages. Magnus Granath's statements indicating that Craig Wright is not Satoshi Nakamoto are not unlawful, and legal costs. So the claim, and this is our fundamental submission, simply does not mirror the English claim. It doesn't mirror it at all. None of the features of the pleaded English claim appear in the pleaded Norwegian claim. And I'll come back to that shortly.
Can I just raise one matter with you? In the statement of claim section, the relief sought, if that's the right way of characterising it, is a finding in regard to the claim for damages raised by Craig Wright. And that also reflects what's in the first sentence of the paragraph above at the end of section 3. We ask the court to find in favour of Granath regarding the claims by Wright. And if one tries to identify what claims are there being referred to, one goes back to the previous page, not sure whether we're calling it 99 or 100, just below Exhibit 6. There's a reference to the 29th of March letter, and then at the end of section 2 we get again Granath this court action in order to decide the claims that Wright believes he has against Granath. Is that to be read as asking the Oslo court to say what has been alleged by Wright in his 29th March letter is what we're asking this Oslo court to say it is not established?
Well, only in my submission, only insofar as that is explained in this document. So we say what this means is that what Mr. Granath is asking the Oslo court to do is to say the claims are wrong insofar as the matters set out in this opening writ are right. That is the extent of this claim. That's why the basis of claim section is important. It confines what it is that Mr. Granath is asking the Norwegian court to find to those facts and matters, and nothing else.
Thank you.
With that in mind, I'm going to turn to Mr. Justice Jay's judgment, and in summary, on the first ground of appeal, we make 5 points about the judgment. First of all, we say that the test applied by the learned judge for the application of Article 27 was wrong, was too low, and does not reflect the requirements as set out in the Alexandros T judgment that we've looked at. And the test that the judge appears to have applied is no more than that there needed to be a significant or substantial degree of commonality or overlap between the two sets of claims. And we'll come on to that in a minute, but it's at paragraph 77 of his judgment. That is the wrong test, it's too low. Secondly, we say that the judge wrongly compared the two claims by reference to defences which might be raised in the English claim. And that is wrong as a matter of principle. Thirdly, we say the judge wrongly identified meaning to be an issue in the Norwegian case, whereas in fact no such issue is identified in the Norwegian opening writ, and there is indeed no hint that it might be taken as an issue. And indeed no evidence from the defendant before the court that he would take that as an issue. Fourthly, the judge wrongly found, on the basis of his finding that meaning is an issue in both claims, that the existence of that issue in both claims is sufficient to satisfy the Article 27 test. And finally, he wrongly held that a finding of truth by the Norwegian court would necessarily render any claim for libel in the English court an abuse of process.
Is that because of the distinction you've drawn earlier about whether a statement is correct?
Yes.
And as opposed to whether it's made dishonestly?
That's the main reason why. There are two reasons for that. The principal reason your Lordship has identified, it's that the Norwegian court could well find the tweets to be true on the basis pleaded in the opening writ, but stop short of finding dishonesty. And in those circumstances,
sustaining a case in England in the terms currently pleaded, namely an allegation on the basis of an allegation of fraud, would not be an abuse of process because the Norwegian court won't have found fraud. How can it be an abuse? But there's another reason for it, whilst I'm on this point, and for that one has to remind oneself of what's in the schedule we looked at of the other tweets, because it is conceivable, I put it no higher than that, but it is conceivable that Mr. Granath could seek to defend the action on the basis of a broader defence of truth. And as I say, in an English libel claim, that would be an arguable way of dealing with the matter. If you sued on these other tweets making general allegations of fraud, you might be able to succeed in your plea of truth, even if you couldn't prove that Dr. Wright made fraudulent claims to be Satoshi. That would be open to you potentially. And the basis on which an English court could find that is because it would find that the meaning of fraud was what libel lawyers call general rather than specific meaning.
I'm so sorry, it's my fault. I haven't followed that. Could you just
yes,
say it again?
As your Lordship would be aware, the way in which pleas of truth are determined in the English court is that first of all the court finds what meaning the words bore. There is a distinction to be drawn between what are termed general meanings, i.e. general assertions of, say, dishonesty or fraud, and specific allegations of fraud or dishonesty. And where the court finds that words bear no more than a general meaning of fraud, i.e. that somebody is generally a fraudulent person, or is generally a criminal person, or is generally dishonest, then it is open to a defendant to prove the truth of those allegations by reference to any fraudulent or dishonest conduct of the defendant. It doesn't matter whether or not it's the conduct specifically referred to in the words complained of, because the allegation is a general one. There was a very good example of this a few years ago in a case brought by Mr. Rothschild against the Daily Mail, where essentially what the Court of Appeal found was that notwithstanding the fact that the newspaper couldn't prove the truth of a specific allegation made in the newspaper, specific allegation of dishonourable conduct, the newspaper could nonetheless justify, as it was then, just prove the truth of the allegation by reference to other matters which the newspaper had brought to bear relating to the claimant's conduct, disreputable conduct. So it is open, certainly in English proceedings, to a defendant to justify prove the truth of a general allegation of fraud by reference to other matters. So it is at least conceivable here, given the breadth of these allegations which are made in these other tweets, that the Norwegian court could find Dr. Wright to have acted fraudulently, but without determining the question of whether or not he dishonestly claimed to be Satoshi. That's possible. That's a possible outcome. But the primary reason why the two judgments may differ to the extent that sustaining the case in England could possibly be an abuse is the one identified by my Lord Justice Singh, the absence of an allegation of fraud. Moving then to the judgment itself, your Lordships will find it at tab 7. The judge reached the conclusion that there was identity and cause, identity of cause and object on two bases. He analysed it on two bases. The first of them, and I'm going to look at them separately, the first of them, which I'm going to analyse secondly, but just in summary, set out at paragraphs 62 to 72. In those paragraphs, he examines a hypothetical situation in which there is no issue as to meaning, either in the Norwegian case or in the English case, and therefore the meaning pleaded by Wright in England, by Dr. Wright in England, dishonesty, is accepted in the Norwegian proceedings to be the meaning that the words bore. That there is no issue that the words bore that meaning, the defamatory in that meaning. So that's a hypothetical which the judge examines. And what he says is that
in that situation, he accepts that there is no overlap between the two pleaded claims, that there are no overlapping issues at all in the way the claims are pleaded, but notwithstanding that, Article 27 applies. So it's on the basis of that hypothetical situation, which we say is certainly, we simply don't know if that's in fact the situation. But on the basis of that hypothetical situation, Article 27 applies. And I'll return to that in more detail shortly. But before I do, I'm going to look at the second basis on which the judge reaches conclusion. And that's set out in paragraphs 73 to 79. And here, the judge is not addressing a hypothetical situation, but the actual facts of this case as he finds them to be. And in summary, what the judge does in these paragraphs is he finds that there is, in fact, an issue as to meaning in the Norwegian case, and that the existence of that issue in both claims is a sufficient basis on which to find that the Article 27 test is met. And we say he was wrong to do that because there is no suggestion in the Norwegian writ that meaning is an issue in that case. And it would have been a very simple thing for Mr. Granath to plead that meaning that he wants the Norwegian court to find the words not to bear a meaning of dishonesty, but he didn't do so, or not to bear any meaning defamatory of Dr. Wright, but he didn't do so. So the judge was wrong to find that there is an issue as to meaning in the Norwegian case. So turning then to paragraph 73, he says, even if I'm wrong in my foregoing analysis, I say that's the hypothetical analysis to which I'll return, there is a second basis for finding in Mr. Tomlinson's favour on this first issue. In that context, I must now proceed to consider the facts of the present case and the hypothetical. In my judgment, considerable caution continues to be required in the opening writ. In Oslo, is subjected to scrutiny by common law. Mr. Granath has expressly put negligence in issue, but the precise meaning of that term in the defamation context is not clear. He has not set out his case in meaning. Well, that, as we know, is correct. But I have no idea whether Norwegian rules of pleading demand this, although my impression is that Dr. Wright's case on innuendo meaning as pleaded in his particulars of claim is correct. I cannot say, one way or another, how this issue would be approached in Norway, nor can my preliminary assessment be regarded as definitive. Furthermore, the fact that Mr. Thompson's witness statement is silent on these questions cannot give rise to the inference that his client would accept the pleaded innuendo meaning. So he is there saying, he's accepting that it's not pleaded in the Norwegian case, he's accepting that the defendant's solicitor has not said that he is going to take the point in the Norwegian case, but he's saying that those matters in themselves can't give rise to an inference that there wouldn't be an issue. And then he says this in 75, it follows that I can only safely proceed on the basis that the Oslo District Court will, or at least may well, be invited in due course to determine what we would call the issue of defamatory meaning, being an issue which is logically prior to those of truth and public interest. At this stage of the inquiry, as Justice Cook's phrase in parentheses, that's whether in dispute or not, becomes relevant. Now, in my submission, far from that being a safe basis on which the judge should proceed, it is an unsafe basis on which the judge is
Is your submission that 75 is a non sequitur from 74?
It is a non sequitur. It is because there is no safe basis on which to proceed. Or rather, it's unsafe to proceed on the basis that meaning will be an issue in the Norwegian case, because there is nothing before the court that suggests that to be so, nothing at all. And as I say, it would have been very simple for Mr. Granath either to plead it as an issue in the Norwegian case, which he didn't, or at the very least to tell Mr. Justice J in a witness statement that that was going to be an issue in the Norwegian case, but he didn't. He did neither of those things. And in the absence of either of those things, then it was unsafe for the judge to proceed on the basis that it was going to be an issue in the Norwegian case.
Do you also draw our attention to those words in line 2 of 75, or at least may well?
We do, and this, your Lordship's right, this is important because it shows that what the judge is doing is looking at whether or not something may happen. And that goes to the test that the judge is setting himself, and it's too low. What the court has to do is identify whether or not there is identity of cause and object. And look at the question of irreconcilability of judgments. And I remind your lordships of what Lord Clark said in Alexandros T. The essential question is whether the claims in England and Greece are mirror images of one another and thus legally irreconcilable. All Mr. Justice J here is saying is there may well be an issue. It's not enough. It doesn't pass the threshold of the claims actually being mirror images of each other and thus legally irreconcilable. And that's why the wording we've drawn attention to in our skeleton argument about the risk of irreconcilable judgments, which is of course the Article 28 wording, is unhelpful. He is merely saying that there may well be an issue. And that's not enough. He has to find there is an issue on the basis of the pleaded case. And he couldn't on the basis of the pleaded case, so he's asserting something here on the basis, we say, on an entirely insufficient and indeed unsafe basis. So he falls into error at this point. He then goes on to say at 76, on the foregoing premise, I consider I'm confronted with a hybrid situation with the following two features. There is an issue common to both sets of proceedings, the meaning of the tweet, and whether that meaning is defamatory. Well, you already have my submissions on that. In fact, there isn't. In that respect, there is clearly a mirror image. Well, that is we make a separate point on that, which is that even if the judge were right that there were an issue as to meaning common to both proceedings, that would not in itself be sufficient to constitute a mirror image claim. It's just one feature of the claim that the two cases would have in common. And you need more. It is just one feature. In addition, the issues raised in Mr. Granath's pleaded case in Norway are not reflected in the particulars of claim. In that respect, I have held that the potential for irreconcilable judgments arises, but in the event that conclusion is wrong, the focus must shift to the area of commonality. Now, that needs a little bit of unpicking. What we understand the judge to be saying there is referring back to the hypothetical scenario that he has looked at earlier in the judgment, which I'll come to shortly, where he says even where there is no overlap between issues, i.e. issues raised in English claim are not reflected in the Norwegian claim, even then potential for irreconcilable judgments arises. And I'll come back to that. That we say is plainly wrong, but in the event that that conclusion is wrong, the focus must shift to the area of commonality. So he's saying that even if I'm wrong about that, we move on to the actual facts of the case, the area of commonality, and the area of commonality is meaning. Paragraph 77, the authorities do not provide a clear answer to the conundrum presented by this case. There are two logically possible approaches. One, whether there is a significant or substantial degree of commonality or overlap between the two sets of claims, and two, whether the matters in common, as opposed to the matters which are not in common, predominate. In my judgment, the first approach is the correct one. Its application leads inevitably to the conclusion that Mr. Granath must prevail on the first issue. So, what he's saying there is that the correct test is that he sets out in number one, whether there is a significant or substantial degree of commonality or overlap between the two sets of claims. Now, that is too low a test. That is not the same as the test that we've seen explained by Lord Clerk in Alexandros T, namely whether the two claims are mirror images of each other and thus legally irreconcilable. It is possibly reflective of the test under Article 28, although we're not sure whether it even reaches that threshold, but it's much more akin to the test under Article 28 in relation to related actions, but what it is not is the Article 27 test. And one notes that he explicitly rejects the other formulation that he has proposed, namely whether the matters in common, as opposed to the matters which are not in common, predominate. So the matters in common on the judge's analysis do not even need to predominate.
That test, number 1 in 77, whether there is a significant or substantial degree of commonality or overlap between the two sets of claims, did the judge get that wording from any earlier authority?
I'm not aware of that having been derived from any authority. I'm sure Mr. Thompson will correct me if I'm wrong. But that is a test, and it wasn't a test proposed to him by counsel. As I understand it, that's a test which the judge himself formulated. These two possible formulations were both ones which the judge formulated for himself, as I understand the position. So going back to paragraph 78, second sentence, an important, relevant, albeit not decisive factor is the clear potential for conflict. Now, 2 points we make about that. One is, again, it's reflective of the Article 28 test rather than the Article 27 test of mirror image, of same cause. We get back to the point made by my Lord Justice Singh in relation to paragraph 75, that there may well be an issue. It's about assessing whether there may be an issue has in common, as opposed to whether there is. And in addition, what he's talking about here is conflicting decisions, not irreconcilable decisions. Now, irreconcilable decisions are different from conflicting decisions. Decisions can conflict and yet be reconcilable. But what the judge is required to identify, as is clear from Alexandros T, are legally irreconcilable decisions. And he's not done that. He's applied a lower test. Going back then to the judgment, that potential arises in relation to the dispute to the defamatory meaning of the tweet. So that's the sole matter that he says the two claims have in common. The second approach I've outlined is incapable of practical application because it's not possible to quantify which issues are somehow the more weighty or important when a comparative evaluation of these different claims is made. All that it is necessary to hold is that there is a substantial important area of common dispute on the issue of meaning, whose resolution, if permitted to occur contemporaneously, would generate the potential vice of conflicting decisions. So again, he is repeating the test that he set out in paragraph 7 and saying that that test is satisfied merely by a potential vice, not of irreconcilable decisions, but of conflicting decisions. And we again repeat the same submission. It is too low a test. It is maybe Article 28. What it isn't is Article 27. The holding follows the steer given by David Richards, Lord Justice David Richards, in the passage I considered, and that's in the Easy Group case. Furthermore, 79, the legal rule forming the basis of both sets of proceedings is the same. The true meaning of the tweet would fall to be established both in Norway and here. And again, it's very unclear on what basis he reaches that conclusion. He excluded from consideration any expert evidence, the expert evidence which my client had sought to introduce us to Norwegian libel law. So there was no evidence before him which he could use as the basis for that conclusion. And as I say, nothing in the pleading suggests that it's going to be an issue that the Norwegian court would have to decide. Then back to 70.
Sorry, can I just raise a matter there? I understand the criticisms you're making, but when we're talking about whether meaning is in issue, we need to be careful to put out of our minds any idea that involves a concept of what is or isn't disputed. We're looking at whether it is something which is part of the claim, which,
yes,
if disputed, would have to be decided
Absolutely.
by the court.
Absolutely.
And what is in the Oslo claim is a claim that the tweet is untrue, it's not correct. How could the Oslo court decide that question without addressing what the tweet meant?
Well, we don't know, is the answer. It may have to decide what it meant as a preliminary matter. It may not. We just don't know. The closest we get to finding out is what's in the opening writ, which is all that Mr. Justice Jay had to guide him. And on the basis of the opening writ, all that can be said is that the Oslo court will be asked to decide whether or not it's true because Dr. Wright is not Satoshi. That's all. And this one matter which, as I say, is noticeably absent from the Oslo writ is any contention that the words were not defamatory at all. Now, another point which is relevant on this is, as it happens, during the course of the argument before Mr. Justice Jay, my old friend Mr. Tomlinson said that his client would seek to establish in the Norwegian proceedings that Dr. Wright had acted fraudulently. Now, we'll come on to that when we look at the first hypothetical basis of the conclusion reached by the judge shortly. But for current purposes, if that is right, then it would appear that it is not a matter which the Norwegian court's going to have to look at, question of meaning. Simply not something they're going to have to decide because it's not going to be in dispute. It's going to be agreed because Mr. Tomlinson's point was, well, it just doesn't matter what the meaning is because we're going to prove fraud. So again, if that's right, then that again militates against this being something the Oslo court is going to have to decide. It's going to have to rule on it. Simply, it doesn't exist as a feature of the case at all. So it's in conclusion on this part of the judgment, it's the wrong test. It's premised on an unsafe assumption as to the features of the Norwegian case. And even if what is said about the Norwegian case featuring an issue of meaning is right, that is insufficient to fulfil the Article 27 test.
So is your point essentially the English claim squarely has to establish that it has meaning A? The Oslo claim may well, I'll put it that way, may well have to decide what meaning it has, but that doesn't mean it will have to decide whether it bears meaning A. It might address whether it has meaning B, C, or D.
Well,
is that the point?
It might not have to address the meaning at all, the question of meaning at all. We don't know. We don't.
Well, that's the bit I'm not quite understanding.
It might not. We don't know whether or not that is an issue that the Oslo court is going to have to look at all.
I go back to my point. It's being asked to decide whether it's correct. It can't address that question, can it, without at least addressing its mind to what it means?
Well,
can it?
From an English libel lawyer's perspective, that's right.
No, I'm not looking at it in terms of libel law, or indeed from the point of view of an English libel lawyer. It just seems to be inherent in the inquiry. If you're asked to decide whether something's true or not, you've got to decide what it means.
Well, possibly. But what we don't know is the essential problem here. That may be inherent in the way the Oslo court approaches the matter, but the closest we get to an understanding of how the Oslo court is going to approach the question of truth is what we actually have in the opening writ. That's all we have. That's all the judge had. Nothing else. And the opening writ demonstrates that the Oslo court is just going to be asked to decide whether or not Craig Wright Satoshi. That's it.
Well, I was going to ask you about that, if I may. Can we just go back for a moment to paragraph 76? In fact, it's both 75 and 76. The judge moves from paragraph 75, where he says, may well be invited in due course to determine what we would call the issue of defamatory meaning, being an issue which is logically prior to that of truth. Shall we just stop there for a moment? And your submission, as I understand it, is that he's fallen into error there, because actually, on its face, the Oslo pleading only identifies the issue of truth. That's the first point you make. But then I'm particularly interested in line 3 of paragraph 76, where the judge gives himself a self-direction that there is an issue common to both sets of proceedings. The first is the meaning of the tweet, which you've been discussing with my lord in the last few moments. But he goes on to direct himself, and whether that meaning is defamatory. Yeah. What's your submission about that?
That's absent from the Norwegian writ. It's not there. There is no assertion. There is no assertion in the Norwegian writ that the words aren't defamatory. It's not there. It's not suggested. It's not said these words did not damage Dr. Wright's reputation, for example, because they're not defamatory. It's saying it says that they didn't cause harm, i.e. that there wasn't harm suffered as a result of the publication. That's a separate matter. But what's not said is they were not defamatory. They were not damaging at all. That is absent. So again, the judge is presuming that that will be an issue in the Norwegian proceedings on an unsafe basis, in my submission. Then, please, I'd like to turn to the other basis on which the judge found that the Article 27 test was satisfied. And this is the hypothetical which he sets out at paragraphs 62 onwards. And I should say, perhaps before moving on to 62, we can have a look at 61, because 61, in a way, sheds some light on the exercise that he's carried out that we've just been looking at. In other words, the actual, as he finds it, the actual position, where he talks about a hypothetical situation, which is in fact quite close to what, or perhaps identical to what he says is the actual situation. He describes it here in 61 as a hypothetical. He says a simple hypothetical version of the present case may throw light on the correct analysis. Imagine the sole issue taken by Mr. Granath's opening writ in the Oslo District Court of what we would characterise the innuendo meaning. On these assumed facts, the case would be the tweet does not bear the defamatory meaning Dr. Wright claims. Notional comparison would be between the Norwegian claim, which denied any defamatory meaning, and a claim brought in this jurisdiction, which averred precisely the converse. In my view, this would be a classic instance of mirror image claims, adjudication of which would lead to legally irreconcilable outcomes. Now, 2 points to make about that. The first is we say that even if that were the case, it would be wrong that if meaning were put in issue explicitly in the Norwegian proceedings, that would be enough to satisfy the Article 27 test. You have my point on that. But also, what the judge is doing there is demonstrating what in fact would be required
in order for him safely to find that meaning is an issue in the Norwegian proceedings. It's this hypothetical. It's a Norwegian pleading that explicitly denied defamatory meaning. So that is what we would need for his actual finding as to what the position is in Norway to be sustainable. My submission. He identifies it there. Now, moving then to paragraph 62 to 72. So this is the hypothetical situation which he posits. He says here, imagine on the other hand another hypothetical version of the present case.
I'm sorry to interrupt you again. When you say that's what would be necessary to establish identity of issues on meaning, but I think your point is you would, perhaps it's not, but would you accept that if in Norway it had said what the tweet means is that Dr. Wright is being accused of a dishonest pretense to be Satoshi, and we say that is true, you'd then have precisely the same, wouldn't you, elements of meaning having to be established as mirror images of each other in both sets of proceedings.
If it raised the issue of meaning in the claim, you may have. If it was explicitly pleaded.
So it's really the distinction.
But sorry, can I just explain? Yes, you may have. We do not accept it would then be a mirror image such as to satisfy Article 27.
I understand that.
But at least it would be tolerably clear that it was an issue in the Norwegian case.
Yes. So it's the distinction really that you're drawing between the meaning not being identified in the Norwegian proceedings.
Well, not being identified, and also it not being raised as an issue at all. But whether or not it was whether or not the actual meaning was pleaded in the Norwegian case. If, for example, in the Norwegian writ it was said, we want the Norwegian court to find that the meaning which Dr. Wright asserts is wrong, without saying what the alternative meaning is, well, that would be, then it would be clear enough that that's an issue.
No, but the point I'm putting to you is it would be sufficient also, even if they said the meaning that Dr. Wright attributes to it is right, and we assert the truth of that. It would still, you would then have meaning as something which would have to be determined as part of the claim in both proceedings.
You might, yes. I think what your Lordship's point is that the fact that it's not disputed doesn't necessarily mean that it needs to be precluded from consideration under Article 27.
Quite. And then one gets back to the question as to whether if you're going to decide the truth in Norway, you have to decide the meaning, even if nothing is said about it.
Yeah.
We've been over that ground. Yeah. Thank you.
So going then to paragraph 62, this is the hypothetical basis. Imagine, on the other hand, another hypothetical version of the present case where Mr. Granath expressly admitted in Norwegian proceedings that the tweet bore a defamatory meaning, averred in Dr. Wright's letter before action, and relied solely on the averment set out in the opening writ. On the assumed facts, the particulars of claim would look exactly the same now, saying that they might plead that the innuendo meaning is not disputed. In this hypothetical situation, which I said I would point out indistinguishable from the instant case, that's quite right. But the centrepiece of both proceedings would still be this particular tweet. Whether it was actually defamatory in this jurisdiction would depend on whether or not it met relevant common law criteria and the statutory test of serious harm. These are matters to hinge on our domestic law. Whether or not there are Norwegian analogues would, it seems to me, to be nothing to the point. The situation would be similar to the German public policy issue with JP Morgan. And this second hypothetical could be simplified so as to eliminate any complications. So if the sole issue on the pleadings is the viability or otherwise of what we would call Mr. Granath's
defences pleaded in the opening claims, writ as claims, what then? He rejects my submission that the fact they're called, that the label that's attached to them, maybe defences, is dispositive. We agree that it can't just be a question of labels, one has to look at the substance of the matter. And then he says that you don't look at the question of whether in dispute or not doesn't provide a solution, because you have to look at basic claimed rights and obligations. He notes that it's unclear whether Norwegian law possesses a structure similar to the common law of defamation, and it's unclear what falls within the envelope of cause of action and defence. And again, we agree with the judge insofar as he's saying you can't look at, if you like, the technicalities of how cases, of the functioning of our domestic law in order to provide an answer to the Article 27 question. It's clear that that's not the case. You have to look at the substance of the claims, the pleaded claims. But he then goes on to say, even with this uncertainty about Norwegian substantive law of defamation, what is clear is that Mr. Granath has pleaded truth and public interest as part and parcel of his claim of non-liability, and it's neither incumbent on nor appropriate for Dr. Wright to set out his particulars of the claim, any facts and matters which in some way preempt Mr. Granath's likely defence in this jurisdiction. And that's right. That's right. That is correct. In this narrow sense, these parallel claims differ from those under consideration in the Easy Group case, where the absence of consent was an ingredient of the statutory and common law causes of action in this jurisdiction. And it was therefore apparent that the issue of consent was common to both sets of proceedings, ignoring any defences. And that's a reference to a case, I don't need to take your lordships to it, but it's, the Easy Group case was a trademark case where there were proceedings both in England and in Cyprus. And what the judge found was that a fundamentally important issue, pleaded issue in both claims, was consent, the consent of the trademark owner or otherwise to use of his mark. And as the judge says here, the difference between the current case and the Easy Group case, in the Easy Group case, the court acknowledged that that issue was pleaded in both claims. And of course, that's not what's happened here. Going back to the judgment 69, it's also clear from the Easy Group case that the exercise in play does entail some examination of the core issues in both sets of proceedings. By issues, I mean what in basic terms each party is averring and claiming. I'm not seeking to break this down into any further into fully detailed application by Mr. Justice Morgan, but the comparison must be limited to the issues raised in Norway on the one hand, truth, public interest and no loss, and those raised in England, innuendo meaning. Is the absence of intersection or overlap critical? So what the judge is saying there is that on the assumption there is no issue as to meaning, there is no intersection or overlap between the two pleaded claims. It doesn't exist. And in that sense, it's unlike the Easy Group claim, where, as I say, the court distilled it down to a fundamental issue pleaded in both claims of consent or absence thereof. So here he is looking at a situation which is not reflected in any other authority, which is a situation where there is no overlap in the pleaded claims at all. And he goes on to consider what the situation then is under Article 27. He says, framed purely in terms of issue estoppel, there would be no necessary irreconcilability in terms of the possible outcomes of parallel litigation confined to those issues. Mr. Granath could succeed in Norway on one or more of the averments he has set out, and Dr. Wright could also succeed in England on the issue of defamatory meaning without there being a conflict. So what he appears to be saying there is it would be possible, absent obviously a Liz Pendant stay, for the claim in England to go to trial and the claim in Norway to go to trial, for the two courts to reach differing conclusions and for there not to be a conflict between the two decisions. That's what he's positing as a hypothesis. Now, in our submission, this is very telling, because you cannot possibly have a case falling within Article 27 where it's contemplated that could happen, that two pleaded cases could go to trial, reach differing conclusions, and yet the judgments not be in conflict. If you like, it gives the game away. It's inconceivable that this is an Article 27 case. But the judge does not agree. He says, however, after careful reflection, I've concluded this is too narrow an approach. In the event that Mr. Granath were to succeed in Norway, either on his averment of truth or public interest, it must follow in my judgment that any proceedings here would and should be stillborn. Even if the words complained of bore a defamatory meaning, the finding in Norway they were true should be the end of the matter. It would be an abusive process to contend otherwise. Now, just pausing there, one of the 5 reasons which I identified earlier on my submissions why the judge was wrong was this, that he wrongly held that a finding of truth by the Norwegian court would necessarily render any claim for libel in the English court an abusive process. Now, I hope that it's reasonably clear on the basis of my submissions so far that is not the case. It is more than conceivable that the Norwegian court could reach a conclusion, as it had been invited to do by Mr. Granath in his opening writ, that the words are true because Dr. Wright is not Satoshi. And that would not be a conclusive answer to the English libel case, and pursuing the English libel case in the face of those findings would not be an abusive process. It would not be an abusive process because the Norwegian court would not have found Dr. Wright to have acted fraudulently. So the judge is, if you like, leaping ahead and reaching a conclusion as to a prospective abuse application on a wholly insufficient basis, my submission. We don't know if the Norwegian court were to find truth, what it would find to be true. We just don't know. It could find, as I say, Dr. Wright not to be Satoshi and no more. It could find, conceivably, by reference to these wider allegations of fraud, that he was fraudulent, but that his claim to be Satoshi was honest. That's possible. It could find that he was fraudulent on some wider basis, nothing to do with, or it might not address the question of whether or not he is Satoshi. We just don't know. We don't know. And we don't know from all we know from the Norwegian opening writ is that the Norwegian court is going to be asked to find that he's not Satoshi. Now, Mr. Tomlinson's answer in front of the judge was, well, hang on a minute, you needn't worry about this because my client is going to assert in the Norwegian proceedings that Dr. Wright did make fraudulent claims to be Satoshi. But in my submission, the court has to be slow to find that a case falls within the ambit of Article 27 on the basis of what counsel says in court. And one reason for that is because what Mr. Granath's legal representatives say to the court here cannot bind the Norwegian court, obviously. The Norwegian court, whatever case is advanced by Mr. Granath in Norway, could find no more than that Dr. Wright is not Satoshi. Could say, well, Mr. Granath has sought to prove that he's fraudulent. We don't find he's fraudulent. However, we do find he's not Satoshi, and therefore the words are true. That's open to the Norwegian court to make that finding. So regardless of what Mr. Tomlinson says, and again, this is unsupported by any evidence that was before the judge, but what Mr. Tomlinson says
is his client's intention in Norway, it is simply not right to say that a finding of truth in Norway will render any claim in England an abuse. That is not right. It might. There's a risk that might happen, but it's no more than that. So going back to 71, the judge was wrong to make that finding. He then returns to what he had said earlier, which is this: it is true that in the event that Mr. Granath's pleaded claims were to fail across the board in Norway, the door would be open to Dr. Wright in this jurisdiction on the hypothetical facts I'm continuing to posit, and the two judgments would not be irreconcilable. So again, he's repeating the point that he made in paragraph 70, which we say again demonstrates this is not an Article 27 case. He says on the basis of the pleaded claims, the two cases could go to trial, the courts reach conflicting decisions, different decisions, reconcilable, and yet the judgments would not be irreconcilable. Well, it can't be an Article 27 case. And then he says this, however, it is the potential for irreconcilable judgments which is key. And again, that's not enough. It's just not enough. These aren't mirror claims if it's merely a question of potential. He then refers to the provisions of section 34 of the CJJA, although he rightly says they weren't brought to his attention, and he mentions Easy Group. And then he says, this is the bottom of page 78, paragraph 72, it was necessary to undertake that exercise. Next sentence up. On one reading of his judgment, Easy Group, he, that's the judge in Easy Group, was seeking to identify areas of intersectional overlap between the respective claims. It was necessary to undertake that exercise in the circumstances of the Easy Group case, but in my opinion, the absence of intersectional overlap is not fatal to Mr. Tomlinson's submission. Well, again, in my submission, it absolutely is fatal to Mr. Tomlinson's submission. I've adopted a broader approach to that question. And then he moves on to the hypothetical that we've already looked at.
I'm having some real difficulty, it's my fault, in following this aspect of the judgment. Is the judge saying in this section, from 62 to 72, that, I hope I don't oversimplify the proposition, but does the proposition amount to saying that even though there is a complete absence of intersection or overlap between the two claims in the two jurisdictions, I am entitled to conclude that they are in fact the same cause of action?
Yes. Yes, that's exactly what he's saying. On the hypothetical basis that meaning's not an issue.
Yeah, and actually, you say that wasn't hypothetical. Those were in fact the facts.
Those are the facts
of the Norwegian claim.
Exactly.
But why did you, those words in parentheses, when something was attributed to you at paragraph 63, line 1, I may have misheard you. You appeared to suggest that you wouldn't point out that it's indistinguishable. I thought you would say that what the judge appears to think is a hypothetical situation is in fact the facts of this case.
Well, not it's very close to it, but of course
right.
what he's positing as a hypothetical is that meaning is admitted in the
I
case.
I see. Whereas here,
nothing
said about it.
It's silent.
Yeah, but can I, just before we leave this particular point, can I also respectfully suggest that we always need to keep in mind that there are logically two distinct issues. One is meaning in itself, and two is whether the meaning is defamatory.
Absolutely.
I can quite understand, of course, as my Lord has put several times to you, that as a matter of language and logic, it is inherent in the finding that something is correct, that you have first identified, at least implicitly, what it means. Speaking for myself only, I'm not necessarily sure that it's inherent in that linguistic exercise that one has already implicitly identified that it is a defamatory meaning.
It's not. Your Lordship is right. You can find something to be true without it being defamatory. However, that wouldn't be a defence under English law, as it happens. It might be in Norway. We don't know. But my Lord's absolutely right. It's a logically prior step in English defamation proceedings to identify a meaning that is defamatory. Otherwise, you can't put forward a defence of truth. You can't defend something that's not defamatory. Yes, so just moving on then to how it is we say that the judge went wrong. We've identified the test which the judge applied, and we've drawn attention to the fact that that is a considerably lower test than the one the House of Lords explained, the Supreme Court explained in the Alexandros T matter. So how did he get it wrong? Now, in terms of his analysis of the legal principles, we take no issue with what he said about several of the leading cases which he cited in his judgment. Gubish, Tatry, Gantner and Maersk were all there. They are important cases in this field. He also summarised the relevant principles in the Alexandros T case. We do say that what possibly led him into error was what he said at paragraph 36 about the Alexandros T case, also known as Starlight Shipping. Which is that Mr. Justice Cook's judgment in the J.P. Morgan case was approved. Now, one has to be slightly cautious about this because Mr. Justice Cook's judgment in J.P. Morgan was cited in the Alexandros T case. Certain passages of it were explicitly approved, but what was not explicitly approved was one passage of some controversy in the judgment of Mr. Justice Cook. Can I ask your lordships to look at that? It is the authority of Primacom. Which is at tab 7 of the authorities manual. We need to consider the facts, but the relevant passage is from 45 to 47. The judgment in Alexandros T referred to paragraph 45 and approved what was said there. We've already seen that. However, it did not consider what was said at 46 and 47 explicitly, and that's more controversial. If I had applied the test set out in Briggs and Rees, I would have come to a different conclusion, because they're suggested that another way of determining the point is to ask whether a decision in one set of proceedings would be a conclusive answer to the questions raised in the other. A decision in the English court would not answer the question which the German courts have to consider as a matter of public policy. Equally, a decision by the German courts would assume the validity of the SSFA under English law, which in the absence of arguments advance to the contrary is the conclusion which English court seems to me, however, this is too narrow approach, since otherwise it would be possible to argue that Article 27 did not apply to proceedings
were a national court's decision based on the application of its domestic law, did not answer the question determined by a different national court. The way the claim is framed and the arguments in support may be taken into account, but ultimately the question must be seen broadly in terms of the judgment sought. Now, although it may not be a matter of significance in this case, because this wasn't a passage which Mr. Justice Jay explicitly cited, it is to be noted that in this judgment, Mr. Justice Cook says that it is wrong, Professor Briggs was wrong, to posit that the correct way of looking at this question is to suggest whether a decision in one set of proceedings would be a conclusive answer to the questions raised in the other. Now, again, as I say, it perhaps matters not because this wasn't something that that the judge in this case placed emphasis on. But we do say that if one looks at Alexandros T and the requirement for there to be, as they put it, legal irreconcilability, that is a reflection of the fact that what Professor Briggs said is right. Legal irreconcilability means that a decision in one set of proceedings would be a conclusive answer to the questions raised in the other. So we say that Mr. Justice Cook was wrong about that. Nothing said in Alexandros T explicitly approved what the judge had said in that case. The Supreme Court approved only paragraph 42 explicitly. In fact, the judge looked at paragraph 45. Again, as I say, he didn't cite 46, but insofar as he had that in mind, he may have been, in our submission, led into error. The essential question, as we say, is whether the claims are mirror images and thus legally irreconcilable. In our submission, what that requires the court to find is that there would be cause of action estoppel. If a court in one jurisdiction made findings, then that would give rise to a cause of action estoppel. And we say that that is, although there is no authority directly on point saying explicitly that is the correct approach, we get some assistance from the judgment of the Court of Appeal in a case called Barclay and McClelland. That is at tab 2. It's a slightly complicated case. It was a case in which an English action by the claimant had failed. There were then French proceedings brought by first the claimant and then the defendant, which then moved to judgment. There was then an English claim by a defendant to enforce a cross-undertaking as to damages, and then an application to stay the English claim by the defendant on the grounds of cause of action estoppel, Article 26, or issue estoppel. Now, true it is that in this case, by the time the matter came before the court, the French action had ended. So it was no longer a claim where Article 21 applied, or equivalent to Article 27, because one set of proceedings had ended. It was instead a case involving Articles 26 and 27, which are about recognition and enforcement. But what the Court of Appeal did in this case is they looked at the two articles and they noted that the approach of the court to the two should be similar. So if one looks at paragraph 26, Lord Justice Dillon says that this is paragraph 26, fourth line, Article 21 does not apply directly in the present case, since the only pending proceedings of the claim in the English court under the inquiry as to damages. The French proceedings have been concluded by the judgment 26th of September, But the case law under Article 21 is relevant, in my judgment, in indicating the broad approach of the European Court to achieving the objectives of the Convention, and we looked at the objectives earlier. There's then reference to Gubish, which is, of course, an Article 21 case. Extensive passages from Gubish are set out. And then at the top of page 211, what Lord Justice Dillon says is this. Then finally, in paragraph 18, the Court referred to the dangers for a party seeking enforcement, that it might be said under Article 27(3) that a judgment should not be recognised. The Court therefore applied the test of same subject matter, the test whether the decision in one court would be inconsistent with the decision in the court of the other contracting state. I cannot see that Article 21 applies here, as I've said, but I pass to Articles 26 and 27 in Title 3, which is headed Recognition and Enforcement. Article 26 provides a judgment given in the contracting state shall be recognised in the other contracting states without any special procedures being required. And Article 27 provides a judgment shall not be recognised in certain events. Subheading 3 is if the judgment is irreconcilable with a judgment given in a dispute between the same parties in the state in which recognition is sought. And he says this, recognition, as I see it, must mean recognition as having conclusive effect. Furthermore, where under Article 21, so it goes back to Article 21, the proceedings are between the same parties and involve the same cause of action, the same subject matter, a judgment must, in my judgment, be binding under Article 26 between all those parties. So what we say, the Court of Appeal, Lord Justice Dillon here is explaining, is that when you look at the test of legal irreconcilability, it means the same as what is required under Article 27, which is that a judgment must be binding between the parties. So that is what we say the court is required to do when looking at a case, an application under Article 27. The judge went wrong when he looked at the relevant test, and as I say, the test that he decided he had to apply was much less demanding than the correct one. In conclusion, then, on the first ground of my appeal, what we say is that the test was wrong. That the judge wrongly compared the two claims by reference to defences which might be raised in the English claim. Now, I haven't concentrated on that. It is explained again in the Alexandros T. The court cannot look at defences, and this is reinforced by another decision which I would ask your lordships to look at briefly, which is the Barclays Bank and NPAM case at tab 12 of the bundle of authorities. Again, the facts don't matter. I'd ask your lordships to turn to page 437.
Sorry, which tab is it?
Tab 11.
Tab 11.
Said tab 12.
I'm so sorry.
Sorry,
It's tab 11. Excuse me.
Thank you.
So this is a case concerning the application of Articles 27 and 28 of the Judgments Regulation, equivalent terms of Lugano. Paragraph 12, Miss Sonia Delaney, QC, submitted correctly, and this is judgment of Lord Justice Morbitt, correctly in my view, that the question whether proceedings involving the same cause of action between the same parties have been brought in the courts of different member states so as to engage Article 27 is to be determined
at the date of commencement of proceedings in the court second seized. And then there's reference to Gantner, and of course that's the important case in which the European Court makes clear that defences have to be disregarded. And 13, I've no doubt, same principles apply to Article 27 of the Judgments Regulations. So the question is whether at the time the proceedings in London were commenced, the court in Milan seized, or must be deemed to have been seized, the claims which NPAN seeks to introduce for the first time in its brief. So one is confined to consideration of the claims at the time when the second court was seized. So you can't look at defences. And that is and the judge acknowledged that in our case, but in my submission, notwithstanding that, fell into error because in considering issues of truth in the English case was looking at prospective defences that may be advanced by the defendant in the libel claim. We didn't even know if they would be advanced. There was no evidence to the effect that the defendant would advance defences of truth, and if so, what defences of truth in the English case. But it matters not, because the court is confined to considering what is pleaded in the claim.
Is it simply a question of looking at the pleadings, or do you stand back and ask a question of substance? Or what are the two claims in the two jurisdictions about as a matter of substance?
Well, no, we say you do have to look at the pleadings because you have to look at claims,
Yes, I see.
pleaded claims, and
The reason I ask, forgive me, Mr. Malansky, is just that, of course, we know that these are independent and autonomous concepts. So whether something is the same cause of action is an independent and autonomous concept. And we also know, obviously, that different legal systems in contracting states will differ, particularly if the substantive law concerned has not been harmonised. And it's readily possible to envisage that in some countries, the law of defamation may require you to plead and prove that a statement is not true as a primary element of establishing the cause of action in the first place. Whereas, as we know, English law doesn't approach it that way. It allows for that to be put up as a potential defence. But are these things to turn on those niceties, or is it to be done as a matter of overall assessment of what in substance is going on?
well, we with respect to, well, we wouldn't describe them as niceties. So the core of the claim has to be examined because, and there are a number of reasons for that. One is because the authorities we say here that the analysis has to be confined to claims. But in the case of libel claims, that assumes particular importance because the reality is the court is never in a position to know at the moment the claim is issued either what defence is going to be advanced, or if a defence is to be advanced, what shape that defence will take. What one's entering into realms of speculation which are not helpful, particularly when it comes to an exercise of this nature. One has to be very forensic about it. In terms of Article 27, Article 28 may be different, of course, but Article 27 confines the court to consideration of claims and claims which are pleaded, and that's the significance. We haven't looked at it. I can do so if required. But the Easy Group case, which is an interesting case, it's a trademark case. But in the Easy Group case, notwithstanding the fact that there were numerous issues in the pleaded cases in both jurisdictions, which may or may not feature in each other's jurisdictions, what the Court of Appeal found was that there was an essential pleaded issue in both claims, which was potentially determinative of the claims, but it was a pleaded issue. And the judge in this case recognised that is a point of distinction. In this case, there is no pleaded issue. You have to have a pleaded issue. So in my submission, this is
because of the restricted nature of Article 27, one has to be very forensic about it and look just at claims. And it's not sufficient to step back, as this judge did, and take a broad brush approach to things.
It is, you emphasise that it's especially important to look at this in libel claims, but is the answer you're giving, or maybe giving, to my Lord Justice Singh, that the autonomous question has been decided, you look at the claims, and it's precisely because there isn't any harmonisation or attempted harmonisation amongst different state jurisdictions in relation to libel proceedings that you are bound to have
Absolutely.
very different ingredients depending on where you are, and therefore it does depend very much on what the local law is as to what the ingredients of the claim are, and what only comes in by way of defence.
It does. My Lord is right. It is a feature of personality rights claims which is different from other types of claims. At the European level, it has been acknowledged that the national rules, the means by which different jurisdictions treat those claims differ and will continue to differ. It is a feature of such claims that will be so. And so my Lord is right. We very much agree that a consequence of that is that the national courts are confined to consideration of the claims, and regardless of how national jurisdictions require claims to be advanced. So, yes.
You say that's a feature of the European jurisprudence. We certainly get it in the Advocate General, Chevrel. Where do we get it in the court?
It is
judgment.
Primarily the Advocate General in Chevrel, to which I'm now going to turn, but your Lordship's right. So, can I then turn to the second ground of appeal, which is, of course, in a sense, although we obtained permission to appeal, first of all, on the second ground, it's really adjunctive, because, of course, if your Lordship's fine for me on the first ground, then that's it. The appeal succeeds, and there's no need to reach a conclusion on the second ground. However, what we say is that even if my Lords are against me on the first ground, the claim in England should be allowed to continue. The question here is, essentially, does the claimant in a libel case have a right to sue in the jurisdiction of his choice? And if so, what should the court do about it in the face of a finding that Article 27 applies? And as already anticipated by my Lord Justice Popplwewell, our case is that where you're dealing with personality rights, claims have features which the European Court has recognised distinctive, different from other kinds of case. And one of those features is that the claimant has the right to choose where to sue. In a sense, it's quite obvious why that should be. A claimant who resides in one jurisdiction will naturally want, if he's libelled in a number of different places, to have his home court decide whether or not he's been libelled. That is natural. He will want vindication in the place closest to his home. But it is not just a question of preference or convenience. And this is a point which we say is important in the current context and generally. One of the consequences of the unique regime for jurisdiction in personality rights claims is that the application of the lis pendens provisions can give rise to genuine injustice in a libel case, or indeed any personality rights case. So, we give two examples. The first is where, as a result of the application of the lis pendens provisions, a claimant is stuck with a claim in a jurisdiction, and that claim may be for global relief, like Mr. Granath's is, but that is a jurisdiction which does not, as a matter of course, grant injunctions. Now, I'm not inviting your lordship to look at the expert evidence in this case, but just as a general point, one can readily see that if that is the case, then a claimant who desires an injunction, and indeed needs an injunction to give effect to his fundamental rights under the EU Charter of Privacy and Reputation, is being deprived of an effective remedy by reason of the operation of the lis pendens provisions, because that jurisdiction is not one which ordinarily grants injunctions. There's a second possibility.
So just I'm sorry to keep interrupting. Does that submission implicitly accept that you can fulfil the même objet in Article 27, even though the form of relief which is claimed, i.e. injunction or no injunction, it isn't the same?
Well, our case here is it's not the même objet, as your lordship knows. The judge rejected that because we say that what we were seeking in the case, in these proceedings, is an injunction. That's at the core of the case, and that is a different objet. But that we haven't focused on that on that point.
I understand that, but I'm just wondering whether, if that's right, the injustice you're talking about can arise, because Article 27 wouldn't be fulfilled.
Well, that's your lordship's right. That's yes, it could arise in those circumstances if the court were to decline an application under Article 27. Your lordship's right. So on the basis that the court first seized could give an effective remedy, then or were to decline an application because it would deprive the claimant of an effective remedy, then yes, the problem wouldn't arise. The problem wouldn't arise. But of course, in a sense, and again, I'm constrained from referring to evidence in this case, but one can foresee a case where the court second sees does not consider that to be a definitive answer to the claim, to the application under Article 27, and therefore the application under Article 27 does not does succeed. So that's the situation we're positing. I mean, my lord is right that if that's an answer to the Article 27 application in a given case, then the problem doesn't arise. But one of the difficulties, as I say, we're constrained from looking at the expert evidence, but it was a feature of this case.
Is there any authority that clearly delineates what object means?
No.
There isn't?
No.
Does it include remedies, as my lord is asking?
It's not confined to remedies. It's one sees in Alexandros T the way in which it's. Let me just find it. Can I come back to you on that?
Yes.
Because, so just getting back.
I'm sorry, whilst we've interrupted you, can I just ask,
of course.
On ground two, are your submissions confined to Article 27, or do you say that the special nature of the defamation rights means that Article 28 shouldn't apply either?
It shouldn't. Yes,
it's all the
It's all the
lis pendens.
It's all the lis pendens provisions.
Right.
It must follow, and of course, it was the equivalent of Article 28 that was in play in the Euro Echo case. So, yes, I mean we do say it must apply to both.
Thank you.
So just coming back to the question of potential prejudice. Because of the operation of the bolus supply principle, which is that you can only get an injunction in respect of online publication in a jurisdiction which is entertaining a claim for global damages. But because of the operation of that, one can easily see how a styming of a claim using the lis pendens provisions could deprive a claimant of the opportunity to bring a claim for global relief anywhere, and therefore to bring a claim for an injunction. So, for example, if a claimant threatened a claim for libel and an individual decided to bring a claim for negative declaratory relief, say in Malta, but just for local damages, then the claimant, or the prospective claimant, the defendant in the Maltese claim, could not counterclaim for an injunction, because the claim would only be for local damages. So it would not be open for him to counterclaim for an injunction, but neither could he bring a claim anywhere else in any other court for global damages. Therefore, he could not bring a claim anywhere for an injunction, because any other claim that he brought within a European territory could not be for global damages, because the Maltese part of the claim would have to be carved out. So the act of bringing...
Your example assumes that Article 27 would be fulfilled in those cases.
Correct, correct.
And therefore that a mosaic claim is the same cause of action as a global damages claim.
In this example, in this example.
Right.
But if that were the case, if a Article 27 application were to prevail in that situation, then one can see that the problem confronted by a claimant is he couldn't bring a claim for an injunction anywhere. So that would give rise to an injustice, and we say a far greater injustice than the one identified by Lord Justice Bean in Euroecho, where he expressed disquiet at the proposition that a claimant could bring claims under the mosaic principle against multiple, against a defendant in multiple jurisdictions at the same time, safe in the knowledge that a finding in one jurisdiction would not necessarily give rise to an irreconcilable judgment in another. So Lord Justice Bean expressed some disquiet about that. Said, well, that could give rise to oppressive multiple claims by a claimant against the defendant. Well, it is true that one consequence of the mosaic principle is that a claimant can do that. But that, in our submission, is a much lesser injustice than the one that I've identified, which is a claimant being deprived of an opportunity to achieve an effective remedy anywhere by use of the lis pendens provisions. So that we say is the problem, and it's a problem which no court has had to grapple with in a global jurisdiction case. Obviously, in Euroecho, what was being examined was a mosaic situation. And we accept, and this is one point made by my learned friend Mr. Tomlinson, that Cheval is different because it's what the Court of Justice was looking at there is a mosaic situation. And we accept that. That's a point of differentiation. But in our submission, it shouldn't matter, because the point of principle is a fundamental one. Whether it's applicable in mosaic claims, whether it's applicable in claims for global damages, should make no difference. The fundamental principle is that a claimant has a right to bring an action in the jurisdiction of his choice, regardless, we say, of whether or not there is a claim for global damages. It is a claim for global damages or under the Mosaic principle. Now, we accept that's a bold submission. It goes further than Cheval, but we say that as a matter of giving effect to fundamental rights under the Charter, it is necessary for the court to find that that is available, and indeed that a claimant has rights in those circumstances. Now, can we go to, first of all, to Cheval itself? As I say, we accept this point of distinction because Cheval is a Mosaic claim. But nevertheless, what was said in Cheval about the nature of personality rights, which I think my Lord or Justice Popplwewell referred to earlier, is important and has general application. The opinion is that of Advocate General Darman at paragraphs 11 to 12. Which I'd invite your lordships to read. The fundamental point that the Advocate General is making there is that personality rights, there are striking differences between different jurisdictions, which are reflected in the different approaches taken in those jurisdictions to personality rights claims.
Yes.
And one sees, in particular, paragraph 12, at D, that what the Advocate General is saying, explaining, is that the difference in approach between different jurisdictions shows that the assertion of jurisdiction in favour of one forum as against another is not a neutral matter. It's not a neutral matter. It goes to the heart of aspects of the personality right. And that is why what the court went on to do, as explained further on in the Advocate General's opinion, is acknowledge that in order to give effect to those rights, a claimant could sue under the Mosaic approach, and this, of course, is the case which established that that was an approach available to give effect to Article 5.3. So a claimant could sue in any member state where publication took place in respect of damage which occurred there, and importantly, that the fact that he could do that did not give rise to the risk of irreconcilable differences, and that's because the damage in the different claims was confined to the different territories. That's how, if you like, the court, first the Advocates General, and then the court explained how a claimant, how the court could enable a claimant to bring claims to have effective remedies in different territories. There was this problem potentially of irreconcilability, but the court said in fact it's not a problem at all. Now, it was those passages which Lord Justice Lewison looked at in the recent Euroecho case, in a passage of some importance. That case is at the back of the file. Tab 18.
The relevant, the judgment of Lord Justice Lewison is short. It's at paragraph 66 and 67. And here he is dealing with the question which has already been looked at earlier by Lord Justice Bean, who, as I say, expressed some scepticism at the proposition that a claimant had a right to bring claims in multiple jurisdictions under the Mosaic principle at the same time. And he said this at 67, so far as the question of irreconcilable judgments is concerned, I wish to reserve my opinion for a case in which it matters. I simply make the following observations, and we accept this is obiter. Judgment in the Tatry was given on 6th of December 1994. Cheval was argued between the Grand Chamber, before the Grand Chamber on 10th of January 95. Judgment was delivered on 7th of March 95. Of the 11 judges who sat in Cheval, 6 had also sat in the Tatry. The Tatry, of course, was a lis pendens case, a fundamental lis pendens case. Neither Advocate General Leisure nor the court referred to the Tatry, which had been decided in the previous month. In Cheval, both Advocates General drew a distinction between conflicting judgments on the one hand and irreconcilable judgments on the other. This does not appear to be the case in the Tatry, which the court referred only to conflicting judgments. The court in Cheval did not cast doubt on the Advocates General's distinction, and its answer to question 6 might be thought to recognise implicitly that the existence jurisdiction did not deprive the claimant of his right to sue. Now, question 6 was the question posed by the House of Lords about whether or not application of the Mosaic principle should be precluded by operation of the risk of irreconcilable judgments, and the court said no. On one view, how Cheval and the Tatry are to be reconciled is not, in my judgment, a straightforward question. On one view, Cheval, and after it edate, gave the claimant the substantive right to sue in each member state where the libel has been published, with the consequence that that right is not to be taken away by procedural means. Now, that is the view that, in our submission, is right. That that's exactly what Cheval does. That's what the Mosaic principle is. It is the right of a claimant to bring a claim in multiple jurisdictions at the same time. And I should say, with regard to this, the scepticism expressed by Lord Justice Bean, and indeed what was described as an unattractive proposition by Lord Justice Baker, that this is in fact not the only realm in which the court, in which the European Court has recognised that claimants are entitled to bring multiple claims at the same time in multiple jurisdictions, because in the IP sphere that also is possible. It's different. Obviously it's only confined to Mosaic, effectively the Mosaic principle, but nevertheless it is a claim for assertion of intellectual property rights can be brought in multiple jurisdictions between the same parties at the same time. And we've referred to the AMS Nevy case which confirms that. So it is not, in our submission, especially surprising that option is available to a claimant in a personality rights case. But open it is. So going back to Lord Justice Lewison's case, we say that he was right about that. That indeed is the only way in which one can properly understand Cheval, that it does give rise to a right to a claimant to sue in multiple jurisdictions at the same time. He does go on to say, on another view, the mere fact that there is a right to begin proceedings in a particular member state does not entail the consequence that the claimant is entitled to prosecute those proceedings all the way to trial. Well, that's a somewhat different matter. What he appears to be anticipating there is that there may come a point at which a claimant who is bringing multiple cases, because he's entitled to do so in lots of jurisdictions at the same time, is prevented from taking one of those cases to trial for reasons which, who knows, maybe application of Article 28, or there may be some other reason why not. But what he's not doing is
questioning or doubting the proposition that Sheville does give rise to that right. There is something to be said for each point of view, so I would prefer not to decide between them in a case in which it makes no difference to the outcome of the appeals. As I say, it is obiter. As we say, the problem which was not dealt with in Sheville or in Euroecho is how to reconcile giving the claimant a choice, his choice of jurisdiction, where the defendant has preempted a claim by bringing a claim for negative declaratory relief, and that claim for negative declaratory relief overlaps territorially. That's the novelty of the current.
Before we get to that novelty, can we take the more straightforward case on any view, where you have not a mosaic claim, but a global damages claim, and the claimant, if you're right that there is a substantive right which can't be precluded by what you describe as procedural rules, then surely it would follow that the claimant has that choice even in that situation. In other words, not only where a potential defendant take preemptive action in one state, but just because the plaintiff, the claimant, has that choice. And then, is that right? Is it your submission that in such a case, the claimant has a substantive right to sue in more than one state?
Yes.
Yeah. Now that would give rise, wouldn't it, to exactly the vice of irreconcilable judgments, which Article 27 and 28 are designed to prevent.
Well, that was the question in terms of mosaic claims,
Yeah,
so
exactly.
non-overlapping claims.
I understand that.
That was the question addressed by the court in Sheville.
Indeed.
And
you're asking this court to extend the Sheville principle beyond the mosaic situation.
Correct.
Yeah.
Correct.
And I'm just wondering whether that doesn't undermine the complete foundation of Articles 27 and 28.
Well, I pretend this is an unambitious proposition. However, what we do say is that such is the risk of injustice, and particularly with the Bolog supply problem, which I hope I've articulated sufficiently,
Yes.
particularly with that problem in mind,
I understand.
that it requires the court, the domestic court, to find a solution, to find a way through, so that a claimant can have an effective remedy. And we agree that this is a novel proposition.
Well, you may be right on the fundamental novel proposition. Speaking for myself only, I would certainly welcome your assistance on whether I don't know, are there more nuanced approaches open to this court? Because as I understand it, what you're really focusing on is the facts of the present case, where you have drawn our attention to the particulars of claim in the English proceedings, and you've shown us that one of the remedies sought is the injunction. And correct me if I'm wrong, but I think that's one of the complaints you're making, that if Article 27 precludes the English claim from proceeding because the Norwegian court is first seized, then your client would be prevented from pursuing his attempt to achieve an injunction. And as I understand it, you also throw into the mix that it's not my straightforward hypothetical. Here you do have the potential defendant in the English proceedings taking preemptive action because Norwegian procedure allows for a negative declaration procedure to be used. I don't know the answer to this question, but I'd welcome your assistance on whether it might be possible for this court to fashion a doctrine which says that where those features are present, it may be that the claimant has the right you contend for. I don't know.
Well, as your lordships will have noticed, what we say is the means by which the court can achieve what we want is by finding that the Article 27 application in effect is an abuse.
Yes.
Now, not every Article 27 application is going to be an abuse. And it may be that that's the answer to your lordship's question, that there will be cases where where the court concludes that in fact that there is no abuse, and indeed there's no respective injustice. And there'll be cases where it is plain that there is an abuse, that all that's happening is that the Article 27, the Liz Pendant's application, is being brought in order to deprive the claimant of an effective remedy in another jurisdiction, or at all in the case of an injunction. And so when your Lordship talks about fashioning a more bespoke regime, we are not contending that that there cannot be an application of Article 27 in any defamation case. That can't be right.
I'm not sure. I mean, you may be right. We'll have to consider the merits of the arguments, because I know you've argued abuse, but speaking for myself only, I'm not sure it's necessarily a case of abuse. It may be that it's the effect of something. Not necessarily because the proceedings are abusive, but because, as a matter of time, the defendant has brought a negative resolution procedure in another contracting state. It's the same cause of action, let's assume, because otherwise you've won on ground one. But you haven't won on ground one, so we're approaching it through ground two. That may be perfectly, I don't know, it may be a good faith action, not abusive, but it simply happens to be a feature of that contracting state civil procedure that they don't grant injunctions. They confine your remedy, let's say, to damages. You contend that in English procedure you would be entitled, well, at least you would be entitled to seek an injunction. The court could grant it to you, and therefore, as I understand it, you draw attention to the fact that somebody's being precluded from what you say is an effective remedy simply by operation of Articles 27 and 28.
Yes.
I'm not sure I would necessarily characterise that as an abuse of EU law, but you're drawing attention to the fact that's the effect of it.
That's the effect of it.
Right.
That's the effect of it. I mean, again, we suggest that abuse is because of the novelty of the proposition, that there needs to be some route by which the court can find that the action should be allowed to continue, notwithstanding the application of Article 27. We've suggested abuse. It may be that it's not necessary to find that the application was abusive, and looking at the state of mind of the claimant in the declaratory relief action. But in a sense, it's a secondary matter. The challenge for the court in our submission is to find a means to enable the claimant to give effect, to have available to him an effective remedy. And it will be fact specific. We accept that. We're not arguing for a proposition that Article 27 of the Liz Pendants can have no application at all in cases of personality rights. That we're not saying.
And just to finish on this discourse, if I may, because certainly speaking for myself, it's helpful. You said in answer to my lord earlier today that I think you said that this applies equally to Article 28 as it does to Article 27. That may be right,
Yeah.
but I was just wondering, speaking only for myself, whether it's actually the absolute character, the mandatory effect of Article 27, which is the real problem on your submission, because it might not be such a problem. If the discretion were available under Article 28, then of course a court can take a more nuanced approach, because it might wait to see what happens. And if it turns out that somebody's not been able to get a complete effective remedy, for example an injunction in another state, then I suppose in theory it might be feasible to allow a second claim to proceed.
Yes, it's undoubtedly right that Article 28 is less problematic in this context, but there may be a situation where the Article 28 test is satisfied, but nonetheless the problem arises. It's possible. It's less likely. We accept that. It's less likely because of the discretionary nature. Article 27 is very hard-edged. That's the Lordship's right. That's where the real problem lies.
Sorry. sorry to interrupt again, but whilst you've been blown off course, you say you're not saying that Article 27 can have no application at all in personality rights cases. Can I just ask you to articulate for me what are the circumstances in which it can or can't? What do you say is the test?
Well, there may,
as to when it applies.
It is only when there is there is prejudice being suffered by a prospective claimant sufficient to merit the invocation of his rights under personality rights to sue in the jurisdiction of his choice. So it is only where the problem which I've identified arises that we say that the court needs to intervene in order to give effect to his rights. And there may well be cases where that is not the case. I mean, for example, there may be cases where there is no question of a claimant seeking an injunction. It's not something the claimant wants, or it's not something that's on any view realistically achievable, and therefore there is no injustice suffered by a claimant by operation of lis pendens provisions.
Well, I think it's inherent in your submission that you're only really looking at a case where there is non-declaratory relief sought in the other jurisdictions, so that the question that was being addressed in the Euro-Eco case of whether a claimant could bring multiple mosaic claims, it wouldn't be objectionable on your formulation. No, perhaps it would. Perhaps I'm wrong about that. Perhaps I'm wrong about that.
Yeah. Lord, I see the time. We've set out the rest of our submissions. I've really covered the ground in summary, hopefully satisfactorily. We've set our submissions on this aspect of the appeal in more detail in our written skeleton argument. The questions which the question which we say is the one that we invite this court to grapple with and to address in this appeal is whether Dr. Wright ought to be allowed to proceed with his claim on the basis we say that Mr. Granath is plainly using lis pendens provisions to defeat Dr. Wright's fundamental rights under the EU Charter. And we say it's obvious that's what's going on here, not least from the chronology of the case. Here is a defendant who didn't respond to a letter of claim, who deliberately made it impossible for my client to sue him by not revealing himself, and then used the NDR procedure in Norway in order to stymie a claim, NDR procedure in Norway to stymie a claim here. And we say it is obvious that that's what's happened. And equally, this is a situation in which we have a claimant who has a right to bring a libel claim in his home state. And therefore, even if Article 27 is satisfied, the court should enable him to continue with that claim, notwithstanding it is a claim for global remedies. We accept that there is a problem here which has not been explicitly addressed in Cheval or in Euro-Eco, namely the coincidence of damages. We say that is not in itself a conclusive answer to the problem. It may be that there is a problem of irreconcilability which the court has to grapple with, but notwithstanding, we say the right is of such fundamental importance that the claim should be allowed to proceed in England, and particularly because, as my Lord Justice Singh has pointed out, the claim here is for an injunction, and it's been made clear by my client in correspondence that it is important to him to achieve that relief. So those in summary are our submissions. They set out in more detail in the skeleton argument. I don't want to eat into my learned friend's time.
Can I, just before we break, when you say that there's a right to bring the action in the home state, that's a centre of interests.
Yes.
But is your submission that you could also, at the same time, sue for global damages at the place of the defendant's domicile, for example?
Yes, we could.
So it is part of your case that you could bring identical claims, both in Norway and in England, for global damages, and Article 27 wouldn't apply?
Yes, that must follow. That must follow. If that's what's required in order to get an effective remedy, there may be a case where...
No, leave effective remedy out of it.
But there may
identical, something which undoubtedly fell within same cause and objet and was in all respects identical.
Yeah, and the reason why a claimant might choose to do that is because in his home state he might not be able to get an injunction, but in the domicile of the defendant he might be able to. And if that's the effective remedy, if that's a remedy he requires, then he should be entitled to sue there in order to get it. So yes, in our submission, that is the position.
I can see he should be entitled to sue there. I'm having difficulty in accepting that he should be entitled to sue in both.
Yes, well, we say he could. He should be able to. If that's what he wants to do, that's his right.
I think you were going to refer to something about the same object.
Oh yes. Can I just check on that and give your lordship the reference after lunch? Would you also mind? Oh no, I have a reference. Yes. Okay. It's Alexandros T. 28. So. Tab 9.
Is the long paragraph.
Paragraph 28, Roman 4. Yes. Page 605. So identity of object means that the proceedings in each jurisdiction must have the same end in view.
Yeah.
That's the meaning of that concept.
It's like circular.
Yes.
Speaking for myself, I'd welcome a little further assistance on the fact that you're seeking different relief. Let's say an injunction as opposed to damages.
Yeah.
Necessarily means that it doesn't have the same.
Can I come back to you, my lord, on that after lunch?
Yes.
Right. Thank you very much. We'll start again at 2 o'clock.
Popplwewell.